I'm not quite sure if that will be a question for that attorney. I'm not sure if it's gonna be Ms. Abden or Mr. Hadid that's gonna be handling the competency cases.
Okay. All right, so before I bring anybody, I was gonna find out who all I need to bring off the calendar, and then I will go and get them.
Okay, once Judge Law comes on and everybody comes on, we can make that announcement about the competency.
All right, thank you so much.
Okay.
Good morning, Your Honor.
Good morning, Deputy Milton. How are you?
I am well. I have a question
Yes, ma'am.
before we get started. I would like to know about the composite calendar. There's 4 females, and I was wondering if I need to bring them around.
Give me the position numbers.
I don't have the position numbers.
Last names?
Carter,
Carter,
McCrary, McDowell, Williams, and Jones, Samira Jones. She is on the SAP calendar. I was just wondering about her also.
okay. Can I get back to you in a few moments?
Yes, thank you.
Thank you. Mr. McLean in courtroom 2, are we ready to proceed? Oh, Mr. Haddad, excuse me. Good morning.
We're muted. Yes, Your Honor, I believe we are ready to proceed.
All right, great. Good morning, ladies and gentlemen. My name is Judge Law, and we are going to proceed with our state all-purpose calendar with the State Court of Fulton County for today, March 7th, 2024 at 9. This is a list of misdemeanor cases in which individuals who were recently arrested and booked at the jail have already had their initial appearance, been assigned counsel, and bonds have already been set in their particular cases. Today, we're going to get a status of the case to see how they would like to move forward as to whether they would like to accept a plea offer from the prosecution and enter into a plea hearing, which could either be negotiated or non-negotiated, or they would consider entering a not guilty plea and the case would be moving forward for trial. Other matters that we may also address are bond modifications, probation revocations, as well as to set aside bench warrants. If you are a defendant charged with one or more misdemeanor offenses, please remember that you have a right to remain silent. Anything you say in open court about the facts or circumstances of your case, your statements can and will be used against you. You have a right to an attorney, and if you cannot afford one of our attorneys from the Public Defender's Office or our conflict defense list will be appointed to represent you. Okay, Mr. Haddad, our deputy in courtroom 2, who would you like to begin with? And we need to unmute, please.
Montes, Ayala here? Right. Yeah. Your Honor, position number 16 is ready for a plea, Judge. I had submitted the paperwork last night, Judge.
Yes, got it. Thank you. Ms. Champion, did you get the email with Mr. Haddad's plea paperwork?
Good morning. Yes, Your Honor, I did receive it.
All right, thank you. All right, this is State versus Derek Montes Ayala, case number 24 CR 855Y. Mr. Ayala was accused of simple battery at a public transit vehicle or station, 2 separate counts of the same offense from February 21st, 2024. Mr. Montes Ayala, you've been advised of your right to remain silent, and your counsel today is Mr. Haddad. This is going to be a negotiated plea hearing. May I place you under oath? Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Mr. Graham, good morning, sir. And what's the state's offer?
Good morning, Your Honor. State's offer in this case on count 1 is 12 months, served 32 days, credit for time served 16 days. That's the period beginning February 21st through March 7th, 2024. Balance probated, an 8-week anger management course, stay away from all MARTA, no further contact with Christopher Matney. Count 2 will merge into count 1.
Mr. Haddad, do you stipulate to the factual basis, venue, and ID?
We do.
And does your client accept these terms?
Yes, Judge.
All right. Mr. Montes, have you consumed any medicine or alcohol recently?
I've been doing, what's it called? They give me, high blood pressure pills here.
Okay. After taking that medication, are you still able to understand what's going on?
Oh, yes, ma'am.
Okay. Are you satisfied with your attorney?
Yes, ma'am.
Is
Yes, ma'am.
anyone forcing you or inducing you to accept a guilty plea today?
No, ma'am.
Has it been explained to you that if you decide to accept the negotiated plea, you would have to give up your constitutional rights to a trial before a judge or a jury? You would not be able to confront your accuser in a court of law, have the assistance of counsel to challenge the evidence brought before you, present your own defenses and arguments, and have the state carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of simple battery at a public transit vehicle or station?
Guilty, right? Guilty?
Are you sure?
Yes, ma'am.
All right. Count 2 will merge into count 1, and your sentence is going to be 12 months to serve 32 days, credit for time served 16 days. As you've completed your jail time for this case, you will then report to probation next Thursday, and that's going to be March 14th before 3 p.m.
Yes, ma'am.
The probation office is located at 132 Mitchell Street in downtown Atlanta. Make sure you are there before 3 p.m. next Thursday.
Yes, ma'am.
While on probation, you will complete 8 weeks of anger management classes. You must begin those classes within 60 days of being released. You are not to return to any MARTA property, which includes their train stations, bus stations, public bathrooms, parking lots, sidewalks, and so forth. Do you understand?
Yes, ma'am. Frederick Stinson. Anthony Wilborne.
Do you understand?
Thank you, Judge.
All right, that concludes the plea.
Yeah.
Stinson? Your Honor, next is position number 26.
Oh, I'm sorry, fellas. I don't want to have no more talk in this courtroom. Only the attorney and the client.
Your Honor, this is position number 26, Frederick Stinson. We're ready for a negotiated plea. I submitted the paperwork last night as well.
Thank you, Mr. Haddad. This is State versus Frederick Stinson, 24 CR 858A, in which he's accused of theft by shoplifting from February 8th, 2024. Mr. Stinson, you've been advised of your right to remain silent, and your attorney is Mr. Haddad. We are going to proceed with a negotiated plea. May I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Repeat, please.
Yes.
All right,
Yes.
thank you. You would need to speak up. I appreciate it.
Yes.
Thank you.
Okay.
All right, good morning, Ms. Folk. What's the recommendation for Mr. Stinson?
Good morning, Your Honor. The state's recommendation is 12 months served 32 days, credit for time served 16 days. That's going to be from February 21st to March 7th of 2024. Balance probated, stay away from the Walmart located at 970 Mansell Road in Roswell, and 40 hours of community service, as well as an anti-theft course. Your Honor, the state would ask the defense to stipulate to the venue, factual basis, and identification for the purposes of this plea.
Mr. Haddad?
Your Honor, we stipulate, the only question I had is a little bit unclear whether the court would be willing to either place him on non-reporting or terminate probation once all the conditions are complete, Judge.
Miss Champion or Miss Falk, perhaps you could give me some updates. What was the bond order from? I recall this case. What was the bond order issued at first appearance?
Let me see, Your Honor.
The bond order, Your Honor, was $1,000 good bond and to stay away.
All right.
It states on the bond order that the defendant had 29 arrest cycles.
All right, thank you. Most likely not, Mr. Haddad.
That's fine, Judge. We're ready to proceed. He's ready to proceed with the plea.
Understood. Mr. Stinson, have you consumed any medication or alcohol?
No,
And have you understood the proceeding so far?
yes,
And are you satisfied with your attorney?
yes,
Has anybody forced you or induced you to take this plea offer today?
no,
If you decide to accept the state's plea offer, you would have to give up your constitutional right to a trial before a judge or jury. You will not have the opportunity to go back to court with your attorney to confront your accuser, challenge the evidence brought against you, present any defenses or mitigating factors you have, as well as have the state carry its burden to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
yes,
How do you plead to one count of theft by shoplifting?
yes,
Your sentence is 12 months to serve 32 days, credit for time served 16 days. The remainder of the time you will serve on probation. You will report to probation every month. While you are on probation, you are to complete an anti-theft class and complete 40 hours of voluntary community service. You must begin the class within 60 days of being released, and you must begin the community service within 30 days of being released. You are to stay away not just from the Walmart on Mansell Road, you shall stay away from all Walmart stores in the state of Georgia. Do you understand, sir?
yes,
If you violate any of these conditions, or if you get arrested again for any other offense, probation has the right to revoke your probation and have you serve out the rest of the year in prison. Please keep in mind that you have 29 cycles right now. That means 29 arrest cycles. And if you get arrested again, the likelihood of receiving a signature bond is very small. Understood?
yes, ma'am.
Thank you. Yes, Mr. Haddad, did you have a question?
No, Judge, thank you.
Mhm.
All right, Your Honor, position number 31, Willie Williams. We're just enter a plea of not guilty, Judge. He just wanted to be present to see the proceedings, Judge, but we're pleading him not guilty.
Understood. Do you waive a reading of the accusation, Mr. Haddad?
I do, Judge.
All right. Mr. Willie Williams is case number 24 CR 863H. Mr. Williams, you've been advised of your right to remain silent, and your attorney is Mr. Haddad. I understand that you will be entering a not guilty plea to one count of battery, family violence. Alleged incident date is February 21st, 2024 in Fulton County, Georgia. Upon your entry of a not guilty plea, the case will be further noticed for trial. At the time of the trial, the prosecution will have to carry its burden to prove the charge against you beyond a reasonable doubt in order to secure a conviction and overcome your legal presumption of innocence. If the state does prevail, you could be convicted and face a penalty of up to a year in prison and or up to $1,000 fine. Given this information, how do you plead?
Not guilty.
Accept your not guilty plea. The case is going to be further noticed for trial. Best of luck. Thank you. Mr. McLean, Mr. Vigilante. We have 3 individuals at different locations. Who is the individual at Oconee County Jail? Your name?
Your Honor, if it's Mr. Walls, which is position Number 29, I've been told this is a DA transfer. So we don't need them.
All right.
Am I
Ms.
right as
Falk?
well?
That is correct. I emailed the transfer on March 5th to all of the litigation managers. I wasn't sure. It was a reset from a previous SAP calendar, so I wasn't sure which litigation manager it needed to go to. So I sent it to all of them in an abundance of caution.
All right. Mr. Reginald Walls at the Oconee County Jail. You are accused of battery, family violence from November 23rd, 2023 in Fulton County, Georgia. Your Fulton County accusation number is 24 CR 380B. You have a right to remain silent, and anything you say during this virtual proceeding, your statements can and will be used against you. You have a right to an attorney, and presently, Mr. Juwan Haddad at courtroom 2 is speaking on your behalf. We have been informed that the District Attorney's Office, which is Superior Court of Fulton County, has accepted your case as a felony matter. So this particular case is going to be transferred to the Superior Court District Attorney's Office to be tried as a felony. So your attorney will give you an update of when the transfer occurs and when would be your next appearance in the Superior Court. Thank you. That concludes the case with Mr. Walls.
And Your Honor, it looks like the order is not in the system yet, so I am going to resend to Ms. Champion for Your Honor's signature.
Okay.
I'm sorry, Ms. Falk, you don't have to send it. I have it. It's in the file folder and it's been signed by Judge Law.
Okay, I appreciate it. Thank you so much.
Thank you.
Thank you. Okay. Jail court iPhone, who do we have?
We have Mr. Anthony Wilborne. I'm not sure of his position. It says 31, but you guys just did a position 31.
Okay. Yes, it's position 30 on my calendar, and that's Mr. Haddad's client. Is that
Okay.
Mr. Haddad, are you ready to move forward with the plea?
Yes, Judge, we're ready. The paperwork has been submitted last night, Judge.
Thank you. This is case 24 CR 000862B, State versus Anthony Wilborne, in which Mr. Wilborne is accused of loitering or prowling from February 21st, 2024. Mr. Wilborne, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Juwan Haddad, who is on courtroom 2 on your Zoom panel. Do you see your attorney?
Yes, ma'am.
Thank you. Mr. Wilborne, may I place you under oath that this is going to be a negotiated plea hearing? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Falk, what are the recommendations for Mr. Wilborne?
Yes, Your Honor. The state's recommendation is 12 months, serve 32 days, credit for time served 16 days. That would be from February 21st to March 7th of 2024. The balance will be suspended. We are asking for no further contact from Mr. Hardy, Hardee, and stay away from 273 Sipple Terrace Northwest in Atlanta, Georgia. The state would ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea.
We stipulate, Judge.
Thank you. Mr. Wilborne, have you consumed any medicine or alcohol?
No, ma'am.
And have you understood the proceedings so far?
No, ma'am.
Have you understood everything that's going on so far?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
Are you entering this plea freely, willingly, and knowingly?
Yes, ma'am.
In that case, are you ready to give up your constitutional rights to a trial before a judge or a jury, and in which you will not have the opportunity to confront your accuser, challenge the evidence brought before you, and have the state carry its burden to prove the charge against you beyond a reasonable doubt? Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of loitering or prowling?
Guilty, Your Honor.
Your sentence is 12 months to serve 32 days, credit for time served 16 days, balance suspended. You'll be released within 24 hours unless you have any other cases holding you at the jail. While you are released, you shall stay away from 273 Sipple Terrace in Northwest Atlanta and stay away from Mr. Hardy. If you are seen anywhere near them, you could be arrested again. Thank you.
Okay. All right.
Thank you, Judge.
Jail court iPhone, did you have another case?
No, not on this floor. I would have to go across the hall. You
All
can,
right, sir. See you
Yeah.
soon. Thank you. Medical, who do we have, please?
This is position number 1, Burgess.
Thank you. Mr. McLean? Mr. Haddad, while you're waiting, if you could look at the, I don't know if Miss Vigilante is there as well.
She is.
All right, if y'all could look at the competency calendar, positions 2, 9, 10, and 16, to see whether they need to be brought to the Zoom camera, and position 13 on the SAP calendar. So
All
that
right.
was 2, 9, 10, and 16 on the competency calendar, and position 13 on the SAP calendar.
I'll check, Judge. As far as the competency, it's normally Paul Bartels. I saw him here a little while ago, but I'll try.
Okay. All right, appreciate it. Thank you. Mr. McLean, you have Anthony Burgess. All right, sir. Are we ready to proceed with the plea?
I think we have that list, Your Honor. Burgess is a negotiated plea, yes.
All right. This is State versus Anthony Burgess, who is at the medical Zoom panel. Case number is 24CR000882C. Mr. Burgess was accused of criminal trespass and willful obstruction of an officer from February 22nd, 2024. Mr. Burgess, you have a right to remain silent about the facts of your case. Anything you choose to say, your statements can and will be used against you. You have a right to an attorney, and representing you is going to be Mr. Michael McLean. Do you see Mr. McLean on the screen?
Yes,
Thank
ma'am.
you. All right. Mr. Burgess, may I place you under oath for purposes of your plea? Raise your right hand.
Right hand.
Do you solemnly swear and affirm that the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Appreciate it. Thank you. Mr. Graham, what is the recommendation for Mr. Burgess?
Your Honor, the state's recommendation, count 1, 12 months, serve 28 days, credit for time served 14 days. That's a period beginning February 23rd through today, March 7th, 2024. Balance suspended, stay away from the Walgreens located at 595 Piedmont Avenue. Count 2, 12-month probation concurrent with count 1. And we will ask the defense to stipulate to factual basis, identification of venue for the purposes of the plea.
Mr. McLean, do you so stipulate?
For said purposes, we do.
All right. Mr. Burgess, have you consumed any medicine or alcohol, sir? Please, Deputy, if you could unmute. Thank you.
Okay.
Yes, sir. Have you consumed any medicine or alcohol recently?
No, ma'am.
Have you understood what's going on so far in your case?
Yes, ma'am.
And are you satisfied with the legal services you've received?
Yes, ma'am.
Are you entering a guilty plea freely, willingly, and knowingly?
Yes, ma'am.
And are you doing so knowing that you would have to give up your constitutional right to a trial in front of a judge or a jury? You will not have a chance to confront your accuser in a court of law. You will not have the opportunity to present any defenses or mitigating factors to challenge the evidence brought before you, and have the state carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of criminal trespass?
Yes, ma'am.
How do you plead? Do you plead guilty or not?
Guilty.
All right. How do you plead to one count of willful obstruction of a law enforcement officer?
Guilty.
For criminal trespass, your sentence is 12 months to serve 28 days, credit for time served 14 days, balance suspended. You are not to return to the Walgreens at 595 Piedmont Road in Atlanta, Georgia. If you return to that Walgreens store, if you're seen anywhere near that store on the parking lot or sidewalks, you will be arrested again. Do you understand, sir?
Yes, ma'am.
The sentence will be concurrent for count 2. Thank you.
Next, we have position number 3 and 4, Finley.
That is also a negotiated plea and an all cross.
Your Honor, would the court, can I give an update on the request that the court inquired?
Yes, definitely.
All right, so Judge, on position number 13 on the SAP calendar, I believe we don't need that person. Apparently, that case, the state requested a reset. So we don't need that individual on position number 13.
Okay,
And then, and as far as the competency judge calendar, number 2, 10, and 16, we do not need.
okay.
Number 9 is a conflict case. So I'm not sure who the attorney is.
All right. Appreciate it. Thank you, Mr. Haddad.
Thank you.
Deputy Milton, are you on the Zoom panel at the present time? Deputy Milton at ACDC? All right, I'll give her that update. Okay.
Oh, Your Honor, before we start, Mr. Finley, could I ask JCS to put in the chat the balance on Mr. Hunt's probation matter?
I'm sorry, what do you mean by the balance on his probation? Does he have a separate probation revocation case?
He does. He's on the main calendar and he has a probation matter today.
All right, who's, yes, Officer Brooks, I guess, Mr. Finley is position.
Finley is 3 and 4. One will be a null pros, one will be a negotiated plea.
Oh, I'm just looking at the probation revocation calendar. Does he have a case there too?
No, Mr. Finley is sitting here ready to do his plea, but I was just wanting to interject that I need some information for Mr. Hunt for later.
Oh, Mr. Hunt, I'm sorry, you're asking somebody else. All right.
Right.
Officer Brooks, if you have that information for probationer Hunt, who is GH position 8 on the probation revocation calendar, 8 and 9. If you have the balance of time that he has left, if you could put that in the chat to courtroom 2.
Yes, Your Honor.
Appreciate it. Thank you. All right, going back to the SAP calendar, positions 3 and 4. We have State versus Wyatt Finley. Position 3 is a bench warrant, 24 FTA 000204. And position 4 is the misdemeanor case 22 CR 002907C, in which Mr. Finley is accused of criminal trespass and another misdemeanor offense, which we will waive sounding. The alleged offenses occurred on May 12, 2022. Mr. Finley, you've been advised of your right to remain silent, and your attorney is Mr. Michael McLean. Mr. McLean, have you shown Mr. Finley the 2 offenses of which he was accused back in 2022?
Yes, Your Honor, we have discussed this at the jail at the visitation booth yesterday.
Appreciate it. Thank you. Mr. Finley, you've been advised of your right to remain silent. May I place you under oath for purposes of the plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
All right. Mr. Graham, what's the recommendation for the criminal trespass and the PI charge?
Well, thanks, Your Honor. The state's recommendation on count 1 is 12 months, served 28 days, credit for time served 14 days. That includes a period from May 12th through 14th, 2022, and February 26th through March 7th, 2024. Balance suspended, stay away from MARTA and adherence to any and all suspensions or bans. Count 2, 12 months probation concurrent with count 1. And we'll ask for the defense to stipulate to venue, factual basis, and identification for purposes of the plea.
For those purposes, we certainly do.
Right.
I think the terminology may be on count 2, since there are no special conditions other than stay away. The state might be intending balance suspended on that as well.
Yeah, I think it was. Did you hear balance probated?
Yes, but I believe I believe they intend suspended rather than probated, if we could clarify.
Just my apologies, Your Honor. Balance suspended.
Okay. I wrote it as suspended, so if you said probated, my brain still interpret as suspended. Sorry about that.
Well, I think I said suspended, but just in case for the record.
Okay. All right, Mr. Finley, have you consumed any medication or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, I am.
And has anybody forced you or induced you to enter a guilty plea today?
No, ma'am.
If you decide to proceed with this plea, you would have to give up your constitutional rights to a trial before a judge or a jury. You will not have the opportunity to go back to court with an attorney to confront your accuser, challenge the evidence brought against you, to be able to present any defenses or mitigating factors, and have the state carry its burden to prove the original charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Ma'am.
Are you prepared to give up these rights?
Yes, ma'am.
Oh, thank you. How do you plead to one count of criminal trespass?
Guilty.
And how do you plead to the other offense?
Guilty.
On count one, your sentence is 12 months to serve 28 days, credit for time served 14 days, balance suspended. And you are to stay away from all MARTA property, buses and trains, the stations, the sidewalks, the facilities, and so forth, in accordance with any active suspensions that they have against you. With regards to the criminal trespass, that will be also 12 months to run concurrent to count two. So that's also suspended. All right, that concludes this case. Thank you. And the bench warrant is null pros.
Next, we have position number 6, Rare.
All
Your Honor, this is a negotiated plea.
right, sir. GF, okay. This is state, as soon as Mr. Gray has a seat. Thank you. This is State versus Leroy Greer, case 24 CR 885D. Mr. Greer is accused of theft by shoplifting from February 20th, 2024. Mr. Greer, you've been advised of your right to remain silent, and your attorney is Mr. McLean. May I place you under oath for purposes of the plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Mr. Greer?
Thank you, Your Honor. The state's recommendation in this case is 12 months, served 34 days, credit for time served 17 days, balance probated, $500 fine, anti-theft course, stay away from the Walmart at 844 Cleveland Avenue in East Point, and we will ask the defense to stipulate to venue, factual basis and identification for purposes of the plea.
For those purposes, we do so stipulate.
All right. Ms. Champion, could you tell me what was the bond order, please, in this case?
It was $1,000 good bond and a stay away from the Walmart.
Any other comments?
No, ma'am.
Oh, thank you. All right. Mr. Greer, have you consumed any medication or alcohol recently?
Medication, ma'am, but no alcohol.
All right. Are you still able to understand your attorney and the proceedings so far?
Ma'am, yes, ma'am.
And are you satisfied with your legal services?
Ma'am, yes, ma'am.
Is anyone forcing you or inducing you to take a plea today?
No, ma'am.
If you decide to plead guilty with this, with regards to this theft by shoplifting, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not have the opportunity to bring your lawyer with you to a court of law to be able to confront your accuser, challenge the evidence brought before you, present any defenses and arguments and mitigating factors, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
You understand that if you have more than 3 theft by shoplifting convictions on your record, that any subsequent arrest will automatically be a felony charge.
Yes, ma'am.
Are you still entering this plea freely, willingly, and knowingly?
Yes, ma'am.
How do you plead to one count of theft by shoplifting?
Yes, ma'am.
Your sentence is 12 months to serve 34 days, credit for time served 17 days. If you have no other cases holding you at the jail, you will report to probation next Thursday, March 14th, 2024, before 3 p.m. While on probation, you will pay a $500 fine. You will complete an anti-theft class, and you shall stay away from the Walmart store at 844 Cleveland Avenue in East Point, Georgia. You are to enroll in the class within 60 days of starting probation. You're to start making payments on your fine within 60 days of being released, with a minimum of a $50 payment every month. Do you understand?
Ma'am.
All right, that concludes your plea. Thank you.
Next, we have position number 7 and 8, Harris Preston.
It's a man. He needed to talk to me before that.
Mr. Preston's ready.
Are we ready to proceed, Mr. McLean?
Are we ready to proceed, Mr. Preston? Mr. Harris?
Yeah, I'm Harris. How you doing today,
I think we are.
I'm good, thank you.
I believe so, Your Honor.
Thank you. This is State versus Preston Harris. Case number 22 CR 3628Y, in which Mr. Harris is accused of simple battery. Second case is 24 CR 779Y, in which Mr. Preston is accused of criminal trespass. The former case is from a June 8th, 2022 incident. The latter is from a February 16th, 2024 incident. Mr. Harris, I understand you will be entering into a negotiated plea. May I place you under oath for these two cases?
Ma'am, if I have the right to ask, how old is that simple battery? Cause I could have sworn I did the time for it. But if not, I still will, negotiate in the plea.
June 8th, 2022. If we need to discuss it further, I'd be glad to ask the court to put this into the calendar so that he is sure of what he's doing today, Your Honor.
All right. As far as I can tell, this was accused back in 2022. There was a waiver of arraignment and a demand for trial on April 17th, 2023. And today you are here on a plea hearing. You've never pled guilty and you have never served a sentence in this case. Is that what your question was?
Yeah, ma'am, I'm here to negotiate a plea.
Right, it is referred to as a negotiated plea. That's the way we label it.
Okay. All
Not
right.
that there was all that many hours spent negotiating.
All right, understood, Mr. McLean. Mr. Harris, you've already been advised of your right to remain silent, and your counsel is Mr. Michael McLean. Yes, sir.
Proceed, please.
Thank you. Mr. Harris, you've already been sworn, you've been advised of your rights, and if you have no further questions about this negotiated plea hearing, Mr. Graham, what is the recommendation for Mr. Harris?
Oh, yes, Your Honor, the state's recommendation on a simple battery is 12 months, served 30 days, credit for time served 15 days. It's a period from June 8th through June 22nd of 2023. Balance probated, a 10-week anger management course, 40 hours of community service, stay away from the Texaco at 1117 Lee Street, Southwest, Atlanta. No further contact with OM Viradia, Viradiya. This is a global recommendation with the next case of criminal trespass. State's recommendation is 12 months, served 42 days. Credit for time served 21 days. That's from February 16th, 2024 until today. Balance suspended stay away from 1296 Murphy Avenue, Southwest Atlanta. I believe it's the Phoenix House. And we'll ask the defense to stipulate to venue factual basis identification for purposes of the plea.
Mr. McLean?
For that purpose, we certainly do, Your Honor. Thank you.
All right. Mr. Harris, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood what's been going on in both your cases so far?
If you wouldn't mind verifying it for yourself, that'd be lovely. If not,
I have no idea what you just said. So you want to repeat your sentence clearly?
yes, ma'am, forgive me. I didn't too much understand the first one, but it did sound like you did say, time suspended. And for the second one, I know to stay away from the Phoenix House, of course.
All right. It looks like Mr. Harris needs a little bit more time with Mr. McLean.
I think so, yes.
To explain the terms of his proposed sentence before I can proceed. All right. So we're going to put a pin on position 7 and 8 and take up the next case, Deputy. Do we have positions 5, 9, 10, 11, 12 ready?
Let's see, 5, Your Honor, I believe it was determined that this would be a second of a type of charge that would be jurisdictional. There wouldn't be any argument I would have.
Okay.
So we discussed that fully. We discussed it completely. And there we are.
Okay. So is Clement Forts in the courtroom?
Oh, no, Your Honor.
Okay. And Mr. Graham, is Clement Forts, are you all intending, or Ms. Falk, are you all intending to transfer position 5 as a felony matter?
Yes, Your Honor. Actually, I just got an email this morning from the DA's office accepting the transfer on 2 of his cases. He actually has another case that was also accepted for transfer. And I have prepared the transfer orders and emailed them to the DA's office this morning for signature.
All right, thank you. Then position 9 and 10, Alfonso Howard. Mr. McLean, is your client in the courtroom? Mr. McLean, I'm sorry, it's muted. I don't have any audio.
There we go. This is not guilty, bond request.
All right. Is that Mr. Howard?
Yes, ma'am. How you doing this morning?
All right, fine, thank you, sir. This is State versus Alfonso Howard. He has a case 21 CR 007890E, in which he's accused of simple assault family violence from June 4th, 2020. The second case is a bench warrant matter from March 15th, 2023, and the bench warrant is 24 FTA 000206. Mr. Howard, you've been advised of your right to remain silent, and your attorney is Mr. Michael McLean. Mr. McLean, do you waive a reading of the accusation for simple assault?
We do, Your Honor.
Mr. Howard, you have been accused of a misdemeanor offense, simple assault family violence, from a June 4th, 2020 incident in Fulton County, Georgia. Upon your entry of a not guilty plea, the case will be further noticed for trial before a jury. At the time of the trial, the prosecutor would have the complete burden to prove the charge against you beyond a reasonable doubt and overcome your legal presumption of innocence.
Yes,
If
ma'am.
the prosecution does prevail, you could be convicted of this offense and face a penalty of up to a year in prison and or up to $1,000 fine.
Yes, ma'am.
How do you plead at the present time?
Not guilty, but I have an explanation.
Well,
With the not guilty.
I would highly recommend.
The reason I said that, because when I came here, You know, even though I'm not guilty, I feel.
Mr. Howard, please stop talking.
Okay, yeah.
Mr. Howard, you have a constitutional right to remain silent about the facts of the case. That's why you have an attorney with you. Whatever you want to say, you should run that by him so that he can tell you whether that's a good thing to say or whether it's something that will damage your case.
Yes, ma'am.
If you decide to keep talking without consulting with him,
Yes,
all
ma'am.
you're doing is making his job a lot more difficult at the time of trial. Do you understand?
Yes, ma'am.
Thank you. All right, so both cases have been, will be further notice for trial. Of course, the bench warrant matter he's got a bond in that matter in order he can make that bond in order to secure the release. So you have a bond modification request as well, Mr. McLean. Let me see.
Yes, Your Honor. There's some difficulty, of course, these days with getting into Odyssey and seeing what exactly is holding him.
Okay.
But
Ms. Champion, just 1 second. If there's some difficulty, let me check on something. Ms. Champion, what is the bond on the bench warrant matter?
1 second, let me check, Your Honor.
This was a bench warrant issued by Judge Morrison. So looks like it's a $4,000 cash bond. Okay. Yes,
That's
now we
correct.
can see. Mr. McLean?
yes, Your Honor. He described to me a series of phone calls that he made during the pendency of this case every week to the clerk's office to make sure he wasn't missed court. So much so that finally they told him, just call every 2 weeks. Every week is not necessary. Just once every 2 weeks will be sufficient. And then it came up on this FTA is dated March 15th of 2023, a year ago this week. Or next week or whatever. So on the 13th or 14th, the day before or the day before that, he was in court and he says he was assigned to an appointed counsel. I don't know if the appointed counsel was a public defender or a conflict defender or what, but he was assigned to appointed counsel. And so Your Honor sees that if he was in court on the 13th or 14th, that probably was a trial week and they're probably talking about what's going to go out first. And somehow he missed the message on the 15th. And he says that he gave the person their phone number, address. He doesn't know how the miscommunication occurred. He wants the court to know that he tried his best, but he was just completely ignorant. And it was only a year ago. It's not like it's 3 or 4 years ago. And and sometimes these cases during the end times of COVID, biologically it's still there, but legally, I think the extension stopped in the spring. So he has a very credible tale to tell as far as these phone calls and missing court. He apologizes for not having been more diligent in the last 52 weeks, but he would like the court to consider a signature bond or lowering his bond on that $4,000 cash payment.
All right. Mr. Graham, do you have a response?
Yes, Your Honor. So the state would object to any lowering of the bond. Mr. Howard does have another 2017 arrest for a simple battery out of Clayton County and 2018 battery family violence. And my odyssey just went down right as I was writing it. And so for those reasons, we would object to any decrease in the bond amount.
All right. I think Miss Tyson, was it? For pretrial? Miss Jackson, I'm sorry, Miss Bridget Jackson, if you're available.
Good morning, Your Honor.
Good morning. Miss Jackson, do we have any incidences with Mr. Alfonso Howard since anything from 2023 or other
No,
than
Your Honor.
no other matters? Okay.
No, Your Honor.
All right, thank you. Bond will be $1,000 surety bond. Original conditions remain. And Mr. Howard, notices are not sent by phone or voice messages, no matter how many times you call. You have to maintain a current mailing address with the court. And whenever summons are sent, they are sent through mail and not through the phone. If you get a courtesy call, that's not your notice. You're supposed to have a valid mailing address.
Right.
Thank you. All right. Okay, next case, please.
Position number 11 and 12. Zartar Hunt.
Your Honor, if I might have just a moment for him to read something. Your Honor, I'm going to recommend to Mr. Hunt that we reset this to Tuesday or Thursday, a time in which I could make a better bond argument for him. I get the feeling there are some things that are to be researched. I think that there are some mitigating factors. I'm hopeful that there are, and I'd like to get hold of some of his relatives who can enlighten me as to a few things and help me make a bond argument for him.
Just give me a moment. Medical, who do we have, please? Medical?
Yes, we have Mr. Anthony Dixon. He's on the competency calendar though. Position number 3 on the competency calendar.
Is Mr. Bartell present, or is this a conflict? I think this is
Good morning, Your Honor. How are you?
fine, thank you. Mr. Bartell, did you want to address Mr. Dixon?
I can, Your Honor. I'd like to be able to go into a breakout room if possible.
With all of us or with him only?
Is Mr. Dixon?
Yes. You want to be in a breakout with Mr. Dixon, is that correct?
Yes, Your Honor. He's on the competency calendar. Are we switching from SAP to the competency calendar?
Understood. So if you can get on a laptop and sign in, we can put you into a breakout
Very
from
well.
that
Okay, I
location.
can do that in the records room, Judge. Thank you.
Okay, as soon as you log in, we'll put you in a breakout with medical. Medical, if you please hold, Attorney Paul Bartell will be logging in and we'll place
Okay.
him in the breakout session. Thank you.
Okay, Judge.
Thank you. One second, Mr. McLean, I'm so sorry, I'm multitasking here. ACDC, do you have any clients there for Mr. Haddad or Miss Vigiletti?
I have Miss Jones, Samira Jones, position 13, Latoya Moore, position 17 through 20, position 23, Smith Johnson Deja, under probation revocation calendar, position 1, Ty Kamen, and Bridget Gary, she was released on yesterday.
Okay. You got the updates on those cases you asked me, right?
No, I'm sorry, I
Okay.
was,
Carter, position 2, do not bring.
okay,
Position 9, we don't know because it's conflict.
okay,
McDowell and Williams, do not bring. And Jones, you have her there, so that's moot.
okay,
All right, thank you.
thank you.
Ms. Vigiletti, if you're ready to address ACDC, Mr. McLean can step aside and have a word with his client, Mr. Hunt.
Yes, Judge, sounds good.
Are you okay with Lisa?
And Mr. Miss Grace, just keep track of when Mr. Bartell comes on, and you can put medical and him.
Will do, Judge.
Thank you. All right, Ms. Vigiletti, we are going to begin with position number 13, and that would be Samira Jones.
Yes, Judge, it's my understanding that the ASG Ms. Fogg asked for this case to be reset because Ms. Jones has some additional cases that are not on the calendar.
All right.
Yes, Your Honor. She has actually 4 additional cases that are not on the calendar. And so the state would prefer to make a global recommendation given the scope of her
Okay.
cases.
May we have the other 4 case numbers, please?
Yes, Your Honor, and I did put those on the calendar as well. 23 CR 005399C. 23 CR 005564C. 23 CR 005565C. And 23 CR 004969C.
Okay. Are these the four of the cases that you're familiar with, Ms. Vigilante?
Yes, Judge.
Okay. And would all these 5 cases then involve additional jail time? Or is the state considering that?
Yes, Your Honor, given the number of cases, the state is definitely going to be asking for additional jail time.
Okay. In that case, Ms. Vigilante, I can reset it to either next Tuesday or next Thursday, depending on, number one, whether next Tuesday is full, and number two, whether that's adequate time for everyone to address this.
Your Honor, next Tuesday calendar is full.
All right, so in just 1 minute, Ms. Jones, just 1 minute, just 1 minute. I'm going to give you your options, but give me a moment, don't say anything. All right, so next, so that took care of premise number 1. Tuesday is full, so it'll be Thursday. Okay, now please unmute Fulton ACDC. All right, Miss Samira Jones, presently on my calendar to address you today is 24 CR 000873F, in which you've been accused of battery and criminal trespass from one incident from February 8th, 2024, which is the battery, and the trespass is from November 23rd, 2023. This is the only case I have on my calendar. It appears that you have 4 other open cases from 2023. Do you understand, ma'am? If you don't understand, you can shake your head or say no. But if you understand, you need to say yes.
Yes, I understand.
Okay, that means you have a total of 5 cases pending against you. And your attorney, Miss Vigilante, and the prosecution are discussing on what would be the offer that the state would provide if you decide to plead guilty. Now, remember these rights. First of all, whatever you say in open court, right now, if you say anything openly, any statement you make can and will be used against you in the treatment of your case. You have a right to an attorney. Your attorney is Miss Olivia Vigilante. If you want further understanding of what is going on with all of your 5 cases, she will be available to speak with you. Do you understand? Okay. So right now, I'm going to reset all 5 cases to next Thursday, March 14th. By then, your attorney will have a better understanding of what is the state's recommendation. In other words, what kind of offer they are making if you decide to plead guilty to these 5 cases or some of them. Do you understand? All right. Now, do you want to speak with your attorney? Or do you understand that the next time I see you will be next Thursday?
Yes, please. I would like to speak to her.
Okay, if you could have a seat down there, she will speak with you as soon as we are done with the other ladies behind you.
Okay, thank you.
All right, position 13, and these 4 cases are all reset to March 14th at 9 a.m. All right, and Mr. Bartel, have we, Mr. Bartel and medical been placed in a breakout? Medical, have you gone into a breakout with Mr. Bartel?
Yes, we're finished with the breakout.
All right, as soon as Mr. Bartel comes back in, we will discuss that again.
Okay,
Next.
we have position number 21 right here too, Mr. Horus Newsom. Did you want to?
Yeah, we can address that as soon as I address ACDC. ACDC, who do we have next?
Position 17 through 20, Latoya Moore.
Okay, Miss Vigilante, 17 to 20 is, are you ready to proceed? Or are you waiting on the offer still?
Yes, Judge, it appears that Ms. Moore has 2 failure to appear charges and then 2 underlying charges. And we did receive an offer on 1 charge, but it looks like we're waiting on some more information for an offer on the 2nd charge.
All right. Ms. Falk, is the state ready to transmit all the global offer or?
I still did not receive the information I was looking for, but I can prepare an offer.
Okay. Deputy Milton, we'll have to wait on Latoya Moore until her attorney gets all the information. And you said the other one was Deja Smith, 23 to 25?
Yes, Your Honor, 23.
And Miss Vigilante, are we ready to proceed?
I do need to speak with her just briefly. We did meet yesterday, but I told Ms. Smith I would speak with her felony attorney before we move forward. So just
Okay, we're going to do a breakout with both your clients at ACDC then. All right, was there anyone else that needed to address that?
The last one, I'm sorry, Your Honor, the last one that I have is on the probation revocation calendar. Position 1, Ty Kamen.
Okay.
I haven't spoken with Ms. Cameron yet. I hadn't heard from probation yet when I had
All
gone
right.
to CDC. So
There we go, the full panel. Okay.
although I just want to ask Officer Milton, is Alexandria Nieves present?
I think you said not to bring her over, right?
Okay. Yeah, I waived her arraignment. I didn't waive her presence.
Oh, I'm sorry. Okay.
It's okay. I mean, she'll be fine with, I've spoken to her many times. It'll be okay.
Oh. Okay. All right. Deputy Milton, Miss Vigilante is going to go on her laptop and then we're going to put ACDC in a breakout with Miss Vigilante because all her clients are there. And then you can organize it accordingly on how to speak with them. Officer Brooks, as soon as Miss Vigilante has spoken to probationer Cameron, then we will address that matter. Okay.
Okay.
Thank you. Miss Vigilante, you need to hop on your laptop, and Miss Grace, please put them in a breakout as soon as Miss Vigilante is there. Mr. Paul Bartel?
So that's Miss Vigilante and ACDC, correct?
Right. As soon as, but let her wait till she
Yes,
gets.
I'm gonna wait till she, yes, ma'am.
Appreciate it. Thank you. Mr. Bartel has disappeared? Yeah.
Yes, Your Honor, I'm here.
All right. With regards to this matter, shall we wait till we address all the other competency cases?
Yes, Your Honor, I'll be able to make an announcement then.
All right. Medical, we concluded with Mr. Dixon. We'll take the next case at your location.
Okay.
Thank you, Mr. Bartel.
Thank you, Judge.
Next, we have position number 21, Mr. Horus Newsom.
Oh, I think that's Miss Vigilante's case, so we'll have to hold on that. Do we have a case with Mr. McLean?
Position 5 is, but that's up there.
Okay. Is Miss Vigilante still in courtroom too, or is she already gone?
No, she stepped out.
Okay.
Yes, Judge, she just signed in. I'm about to put in the breakout.
All right. All right, Mr. McLean and Mr. Haddad, in courtroom 2, do you have any clients in the courtroom ready to address?
Blake Kennedy?
No, that's upstairs.
Yeah, ready? That's right. Come on. Yeah, we're just gonna reset, huh? We're just gonna reset. Okay, come on. Again, you can.
Oh, Mr. McLean, on your client,
Position 11 and 12.
yes.
I do have his permission now, Your Honor, to ask the court for a 1-week reset on Mr. Hunt. I think that would be wise.
All right, position 11 and 12 are reset to March 14th at 9 a.m.
Thank you, Your Honor.
Thank you.
Next, we have position number 7 and 8, Max Harris.
Preston Harris, I believe is ready.
All right. Have you explained the details of the negotiated offer from the state to Mr. Preston Harris? Mr.
I have.
Montes? All right.
I have done so.
All right, so we will pick up where we left off. I believe that I was asking Mr. Harris if he is satisfied with the legal services he has received.
Yes, Your Honor.
And have you understood the terms of the plea offer as indicated by the prosecutor, Mr. Graham, and by your attorney?
Yes, Your Honor.
And are you entering this plea freely, willingly, and knowingly?
Yes, Your Honor.
If you decide to enter a plea to these two cases, you will have to give up your constitutional right to a trial before a judge or a jury. You will not have.
Forgive.
Just listen to it.
If you decide to plead guilty to these charges today, you will not have an opportunity to a trial before a judge or a jury in the future. You will not have the opportunity to have an attorney with you to go back to court, to confront your accuser, to challenge the evidence and the witnesses brought against you, to present your legal defenses, your arguments, and any mitigating factors if you choose to do so, and have the prosecution carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor, I am.
How do you plead to one count of simple battery from June 8th, 2022 in case 22 CR 3628Y?
Guilty.
Your sentence for the simple battery charge conviction is 12 months to serve 30 days, credit for time served 15 days. Balance will be probated. You will report to probation next Thursday, which is March 14th, before 3 p.m. While you're on probation, you will report to probation every month. You will complete a 10-week anger management program, which you must begin within 60 days of being released. You are to complete 40 hours of voluntary community service, which you must begin within 30 days of being released, and you must do at least 5 hours per month. You're to stay away from the Texaco, I think it was the Texaco gas station.
Yes.
1117 Lee Street in Atlanta, Georgia. With regards to the second case, 24 CR 779Y, how do you plead to one count of criminal trespass?
Guilty.
Your sentence will be concurrent to the same offense for simple battery, which means that you will do the same thing. You don't have to do it twice. You can just do the anger management and community service, and it will apply to the criminal trespass. And it would be, but it will be 12 months to serve 42 days, credit for time served 21 days. Oh, I'm so sorry. This will be balance suspended. So your sentence for the criminal trespass is completed. You are to stay away from 1296. I wish I could read my writing, but it's the Phoenix House. You cannot return to the Phoenix House. Do you understand?
Yes, ma'am, I do.
All right.
Right, it's 1296 Murphy, PA.
Murphy, that's what that word was, Murphy Street.
Oh, Murphy, not the Phoenix, but Murphy.
No, that is the Phoenix House. That is the address of the Phoenix House. It's on Murphy.
Yes, ma'am.
All right, that concludes your sentence. Don't forget to report to probation next Thursday before 3 p.m. Thank you.
Thank you, Your Honor.
Ms. Vigiletti, we have a client in medical, position 21, I believe, Horus Newsom. Ms. Vigiletti, is she coming back to the courtroom? I'll be right with you, Deputy Milton. Yeah.
No, she lost audio. That's why we came out of the breakout. So I believe she's gonna come. She couldn't hear anything on her laptop.
Oh, I see. Okay. She's out of the Zoom? Okay.
Yes.
All right, so we're waiting for Ms. Vigiletti. Please mute ACDC until she returns. Courtroom 2, do we have any other cases to address?
The other cases that we have are up on the floor, so we're just waiting for Joe Court's iPhone. And then the rest is Vigilante's clients that's in court too.
Okay. All right. So all our probation cases are elsewhere and the add-ons? Deputy?
IB work, Jermaine, IB position number 1 through 4 on the add-ons is en route to the courtroom.
Okay. Is in
It's en route to courtroom.
okay. Okay. Yes, Ms. Fall?
Your Honor, just to refresh everyone's recollection, that was the case where PD Vigiletti provided the documentation showing that the defendant was in custody in another county, and the state did consent to a lifting of the bench warrants on that and asked Ms. Vigiletti to prepare an order, which I believe she may have, but
Yes, I did. I attached it to my announcements.
got it.
Okay. To resubmit that, I read those, but I didn't see the attachment. Or maybe Ms. Champion has it. Ms. Champion, do you have the proposed order to lift the bench warrants for?
Yes, ma'am, I do.
Okay, then we're good then. Okay. Then, and then Ms. Vigiletti, Alexandria Nieves,
Yes, she will be pleading not guilty today.
all right. So if she appears, we'll arraign the case. Otherwise, you'll enter a waiver of arraignment?
Sure.
Okay.
I'm sorry, Judge. I do still need to speak with the women at ACDC. My
Yeah.
Zoom, I have no audio.
Okay. We're gonna put you in a breakout.
I'm trying to do it now, Ms. Vigiletti.
I'm wondering because I do think it's my computer. I had to update it yesterday with this because of the system issues, and now I have no audio on Zoom. If we handle these two gentlemen, maybe we could just put this whole courtroom into the breakout.
All right,
Can
Deputy,
we do position number 21 before she do that, then, so I can take him back?
yeah, I'm definitely doing that. I just need to make sure if I've addressed the two gentlemen in courtroom 2.
Yes.
So do they need to remain there?
These two are both my clients. We haven't addressed
I
this.
see. Okay, all right. Okay, Ms. Vigiletti, we'll address the gentleman at medical right now, who is Mr. Newsom. Are you ready to move forward with that?
Yes, Judge. Mr. Newsom is prepared to take a plea today.
All right. So this is position 21. Horus Newsom is case 24 CR 856J, accused of criminal trespass from February 21st, 2024. Mr. Newsom, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and your counsel is Ms. Vigiletti. May I place you on the oath for purposes of the plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I do.
Thank you. Ms. Folk, what's the recommendation for Mr. Newsom?
Yes, Your Honor. The state's recommendation is 12 months served, 30 days, credit for time served, 15 days. That's going to be from February 21st to March 7th of 2024. Balance suspended. Stay away from Lenox Mall located at 3393 Peachtree Road, Northeast in Atlanta. That's all for the state, and we would ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea.
We do.
Mhm. And Mr. Newsom, have you consumed any medicine or alcohol?
No, ma'am.
Repeat your sentence. Repeat your response. I didn't hear it.
No, ma'am.
Okay. And are you satisfied with your attorney?
Yes.
Are you able to understand everything that's going on in your case so far?
Yes.
And is anyone forcing you or inducing you to take a guilty plea today?
No.
If you decide to plead guilty, you will have to give up your constitutional right to a trial before a judge or a jury. You will not have the chance to go back to court with your attorney to confront your accuser, challenge the evidence brought against you, and have the state carry its burden to prove the charge against you beyond a reasonable doubt. Are you prepared to give up your rights?
Yes,
How do you plead to one count of criminal trespass at Lenox Mall?
guilty.
Your sentence is 12 months to serve 30 days, credit for time served 15 days. Balance suspended. Your sentence for this case is concluded. However, if you return to Lenox Mall, including its sidewalks and its parking lots at 3393 Peachtree Road, you will be arrested again. Do you understand, sir?
Yes.
You have to stay away from that location. I'm not sure until when, because it is according to how long they have given you the stay away by the Lenox Mall security.
Your Honor, there was no date that I saw, and so we would ask that it be for the period of 12 months.
Okay, there you go.
Thank you, Judge.
Thank you, Mr. Newsom.
I don't know.
Ms. Vigilante, what would you like to do next?
Position 24, Mr. Wendell Ren.
And Ms. Vigilante, I did go ahead and send you the recommendation on Ms. Latoya Moore. I was able to get a response in the interim from the DA's office.
Okay, great.
Are we proceeding with the plea?
Yes, Judge, I did have one request for the state and the court to consider. I don't know that it's significant enough to consider this a non-negotiated plea, but Mr. Redden is homeless, and while he is working with our social worker to get some housing and some stability, he was wondering if you would be willing to convert the $500 fine to community service.
Your Honor, from the state's posture, this is statutory. This is the defendant's, I generously said third offense. He had some other municipal court theft by shoplifting convictions that we did not consider. And so we cannot waive the fine as part of the plea negotiation because it is a statutory fine.
What's the term of probation in this case?
It is 12 months probation, serve 34 days with credit for time served 17 days.
All right. So he can pay the $500 fine over the course of the remainder of the 11 months. I will waive his probation fees for the first 5 months.
Thank you, Judge.
But unfortunately, he will need to get a job and start paying off that fine. It's statutory. Of course, if he does not want to pay the fine, then he has a right to invoke a trial, and we can further notice this case for trial if he wants to enter a not guilty plea. Those are his options.
Okay.
Or you can mute your screen, Ms. Vigilante, if it's more comfortable.
We are prepared to proceed, Your Honor.
All right, thank you. This is State versus Deja Smith Johnson.
This is Wendell Ren.
Oh, I'm so sorry. Is this position 20? Oh, sorry, wrong page number. Sorry about that. This is position 22. State versus Wendell Quentin Redden. And does he have any other matters? Okay. And Mr. Redden is accused of theft by shoplifting from February 20th, 2024. Case number is 24 CR 8518. Mr. Redden, you've been advised of your right to remain silent, and your attorney is Ms. Vigilante. This is going to be a negotiated plea hearing. May I place you under oath? Mr. Redden, you need to raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I do.
Thank you. All right, Ms. Falk, what is the recommendation?
Yes, Your Honor, the state's recommendation on count one is 12 months probation, served 34 days, credit for time served 17 days. That's going to be from February 20th to March 7th of 2024, a $500 fine, anti-theft course, stay away from the Amico located at 605 Boulevard Avenue, and we are requesting an ADET. As I stated, this will be his third offense in state court. And so if he does have another theft by shoplifting offense, it would be considered a felony. We would ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea. And just to let the court know, this defendant did also appear on the add-on calendar on position 8, but that is a duplicate of the case that's on this calendar.
I appreciate it. Thank you. Miss Vigiletti, do you stipulate to the factual basis, venue, and ID for this case?
We do.
All right. Mr. Redden, have you consumed any medication or alcohol recently?
No.
And have you understood the proceedings so far in your case?
Yes, yes,
Are you satisfied with your attorney?
very satisfied.
And is anyone forcing you or inducing you to take this guilty plea today?
No.
If you decide to plead guilty to this charge, as Ms. Falk has indicated, this will be your third shoplifting conviction on your record. Any subsequent arrest for shoplifting will automatically be a felony charge. Has that been explained to you?
Yes,
Are you still willing to move forward freely, willingly, and knowingly?
yes,
In order to accept your guilty plea, you would have to give up your constitutional right to a trial before a judge or a jury. You will not have the opportunity to have your attorney present with you in a court of law, to challenge the evidence brought against you, to confront your accuser, present any defenses or arguments, and have the state carry its burden to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
yes.
How do you plead to one count of theft by shoplifting?
Guilty.
Your sentence is 12 months to serve 34 days, credit for time served 17 days. Your balance will be probated. You will report to probation every month, beginning next Thursday, March 17th, 2024. I will waive your probation fees for the months of March, April, May, June, and July. August 1st, 2024, you will start paying probation fees, and you will continue to report every month until the remainder of the 12 months are completed. You are to pay a $500 fine, and you will begin paying that fine within 60 days of being released, and you must make a minimum of a $50 payment every month. You're also to complete an alcohol and drug evaluation and submit yourself to any treatment that's required. That must be done within 30 days of being released, and you may do that at any healthcare provider, including Grady Hospital. At all times, you are to stay 200 yards away from the Amico gas station at 6105 Boulevard in Atlanta, Georgia. If you're seen anywhere near that location or in the store, you will be immediately arrested for trespass. Do you have any questions about your sentence?
No.
Judge, could I ask if Mr. Redding completes the requirements of his probation, would you consider converting to a non-reporting status?
This is his third shoplifting conviction, is denied.
Okay, thank you.
All right, that concludes Mr. Redden. Your next case, Ms. Vigiletti?
That would be position number 27 and 28. Daryl Stokes.
Thank you.
Hey, ready.
Judge, Mr. Stokes' case involves significant medical information. Could we possibly address his case in a breakout room? And I know his wife, Miss Annette Stokes, is also on Zoom with us today.
All right, Miss Annette Stokes, all right, is that Annette Stokes? All right. Miss Grace, could you place courtroom 2? Myself, Miss Falk, anyone else joining us? No, all right, just the 3, and I'm sorry, and Miss Stokes, who has got the Zoom panel name MCCOU into a breakout.
And
Okay.
I'm sorry, Judge, Angela Benson is also here for Mr. Stokes.
I don't know who that is. Nobody else has appeared on video.
Angela Benson is. Thank you, That's Mr. Stokes' sister, and she's here on Zoom with us.
Angela Benson would like to be included in this breakout. She needs to start her video and unmute.
Yeah, because I don't see them.
All right. Miss Grace, go ahead and put the 1, 2, 3, 4 of us. And when Miss Benson starts a video and unmutes, then you can put her in there too.
Your Honor, if I may just briefly, PD Vigiletti, is this a negotiated plea but for the no further contact stay away?
I did send an email yesterday with a lot of medical information and a counter offer.
Okay. All right. Let me take a look at that.
So go ahead and put y'all in the breakout room, Judge.
Yeah, except Angela Benson until she unmutes and start a video. Okay?
Oh, okay.
Thank you. All right, Miss Angela Benson, we are going to remove you from Zoom until you are parked. Miss Grace, please remove Angela Benson. Good Lord Almighty, why would we take these risks?
Miss Benson?
No, this is Sharika Robinson, his other sister.
Okay. Would you like to be added?
Can you please?
And your name is Sharika Robinson?
Yes.
Okay. Miss Angela Benson.
They said they was waiting on her to park.
Rika, can they hear me?
She couldn't hear you at first, but she probably can hear you now. When she come back in and call your
I
name.
just got in my car. I was thinking, okay, I'm getting ready to park so I can I need her to put me back in. I was clicking all them buttons trying to get back in.
Are you parked, Ms. Benson?
Yes, ma'am.
Okay. You have to turn your camera on.
Okay.
I need to turn my camera on too.
Yes, your cameras have to be on when speaking to the
Okay.
judge.
I'm just pulling into another parking space because I just left the courthouse.
Mm-hmm. Yes,
Okay,
ma'am.
I'm sorry. Just doing. I'll be parking again in just a few minutes. Somebody just whooped in front of me.
All right, we are going, oh, can you hear me? We're going to hold off on Daryl Stokes until all interested parties have appeared and are not driving and so forth. So I have someone on the name iPhone in a white t-shirt. What's your name? Could you please unmute and identify yourself?
I'm Sharika Robinson. I'm Daryl Stokes' youngest
That's
sister.
understood. Thank you. Please mute your screen. Miss Champion or Miss Grace, can you rename that Zoom panel to S. Robinson? And then
Yes.
Angela
Yes,
Benson.
ma'am.
Benson, you need to start your video and mute your screen. Start your video and mute your screen. Angela Benson. All right, and I understand that the other party is still trying to connect to audio. Angela Benson, start your video.
It says that I've been disabled.
Okay, go ahead and give her a prompt for start video.
And Judge, I believe
Will
that
do, Judge.
folks here with us as well.
All right. Ms. Benson, mute your video. Now remember, if anyone is not conducting themselves appropriately on Zoom, including driving, we will remove you from Zoom. Do you understand? Okay. All right. Miss Vigilante, we're going to hold off on Mr. Stokes if he can be placed back there. In medical, who do we have? Miss Stokes, mute your screen. It's a very simple instruction. Start your video, mute your audio. Simple. Thank you. All right.
Probation 2 and 3. This is
Probation 2 and 3. Is this Antonio Carter?
It is, Judge.
All right. All right. This is State versus Antonio Carter on our probation revocation matter, case number 23 CR 3491E, in which Mr. Carter was convicted of one or more of the following: theft by receiving stolen property, possession and use of drug-related objects, and giving false information to an officer. Incident date was May 31st, 2023. Mr. Carter's probation revocation case is 24 PV 293. Mr. Carter, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and your counsel is Mr. Jawan Haddad. Mr. Carter, do you see your attorney on courtroom 2?
I see him.
Oh, okay, that's good. Officer Brooks, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor, I do.
Thank you. All right, Officer Brooks, what was Mr. Carter convicted of, when, and why are we seeking a revocation? And question number 3 is, what's the recommendation? Sorry, I always repeat the questions if you forget.
Thank you, Your Honor. He was seen by you, Your Honor, actually on June 15th, 2023 for charges of theft by receiving, possession, and or use of drug-related objects, giving false information to a police officer. He was sentenced to 12 months probation, a shoplifting prevention course, and 40 hours of community service. He has 246 days remaining on probation. The probationer has never reported to probation. And that is why we are here, Your Honor. And my apologies. He also was ordered to complete 40 hours of community service. And we're asking that he continue on since he does have 246 days remaining, but we would also like deadlines for him to complete his conditions.
Okay. So he's never reported since June 15th?
Correct, Your Honor.
All right, okay. Well, Mr. Haddad, I'm feeling really blue about that. How do you feel?
Judge, I, in all honesty, I don't have any legal arguments to be made. I will say that my client is currently in medical, and I'm not sure if there's something happened to his jaw, but he has difficulty speaking, so I can have a difficult time hearing him. But having said all of that, Judge, there's enough time left on his probation. He's been in, I'm not sure what his date of arrest, Judge, but I mean, sitting in jail for another week or two. If he had any confusion as to whether he was supposed to be on probation or not, he shouldn't have any more. As I went over the probation's recommendation, and I went over the requirements that he was supposed to do a few months ago, Judge. That's all I have to offer, Judge. I would just ask the court to consider that this is his first violation. At least he does. I'm not aware of any new charges. So I would just ask the court to consider, just give him yet another chance, Judge, by essentially giving him time served and reinstating him with a deadline. I agree with probation. I think a set limit, because if he does not complete that, then obviously a warrant can be issued right away.
Right, please unmute medical. Mr. Carter, after you were convicted of these offenses, you were supposed to report to probation. Do you have a problem reporting to probation from now on? You need to speak up.
I can't. My mouth is wired up.
Oh, I understand you perfectly. Do you have a problem reporting to probation from now on? Okay. I am going to accept the state's recommendation. This will be recorded on your record as a probation violation. You are to report to probation. Today is Thursday, so you will report to probation on Monday. Do you understand?
Yes, ma'am.
Which is going to be March 11th. And you must report to probation before 3 p.m. If you don't show up, just come straight to jail, because probation will be authorized to issue another warrant. Do you understand? While you're on probation, you will complete the anti-theft class that you're supposed to have done, and you will do that class within 30 days from today. You are also to complete 40 hours of voluntary community service work at any nonprofit agency that's not a church and not a school, and you must begin those hours within 30 days from today, and you must do at least 10 hours of work every month. Do you understand?
Yeah.
And you are to report to probation every month.
Yes.
If you don't report, if you don't do at least 10 hours a month, and if you don't complete your anti-theft class within the next 30 days, probation is authorized to issue another warrant, and you will complete the rest of the 246 days or whatever is left in prison. Unless you just want to do prison time right now. That's also an option.
No, I ain't trying to do prison time.
If you don't want to do prison time, then you better report to probation next Monday and every month thereafter.
All right.
Thank you.
Thank you, Judge.
All right. Miss Vigiletti?
Yes, Judge.
Officer Brooks, I don't know where the rest of the probationers are, but we will definitely summon you when one appears, okay?
Okay, thank you, Your Honor.
Ms. Vigiletti, are you ready to address any of the cases at ACDC? Ms. Vigiletti,
Yes, Judge?
are you ready to address any of the cases in ACDC, or you still need to talk to them?
Right, as I said, I wasn't able to get on
Understood.
it, so.
Okay.
Some.
All right. So, Miss Grace, ready with your magic fingers? Please place myself, Miss Falk, courtroom 2, and the 3 ladies who are present, Miss Stokes, which is MCCOU, S. Robinson, and Angela Benson, in a breakout room.
Yes, ma'am.
Miss Robinson, Miss Benson, and Miss Stokes, you will see a message on your screen to join a breakout room, please. Please look for that message because you'll need to click on it in order to join the conference. Miss Grace, am I in breakout room 4? All right, this is State versus Daryl Stokes, 21 CR 7901E, accused of battery, family violence from December 22nd, 2021. Mr. Stokes, you've been advised of your right to remain silent, and you have been appointed counsel, Ms. Vigiletti. We've had a conference with regards to the proposed plea. This is going to be a non-negotiated plea hearing. Mr. Stokes, if you please raise your right hand. Do you, for the purposes of the plea, do you solemnly swear and affirm the testimony provided will be the truth to the best of your knowledge?
Yes.
Thank you. Ms. Falk, if you'd like to put the state's recommendation on record, please.
Yes, Your Honor. The state's recommendation is 12 months, serve 90 days, credit for time served 27 days. That is from December 22nd, 2021 to December 27th, 2021, and February 16th to March 7th of 2024. The state is agreeable to modifying to a no further violent contact with Annette Stokes family violence intervention program, and we are agreeable to that being done virtually, as well as no firearms, and our recommendation did include community service, which we are willing to waive. However, the state is unwilling to waive the jail time, given that this defendant has an open case for aggravated assault from 2022 family violence. This case, a previous failure to appear from 2017, as well as an aggravated assault where he received first offender, and that was also an aggravated assault family violence, and received a sentence of 10 years on that case, which was then sealed, and a family violence simple battery where we are not showing a disposition. Out of 13 cycles, that is approximately 5 of his cases that involve violence and involve family violence. And for that reason, the state is unwilling to modify the jail time given those circumstances. That's all for the state, Your Honor. And we would like to sound for Miss Annette Stokes. I know she is here just in abundance of, just in following Marcy's law, we are sounding for her.
Okay. Mrs. Stokes, if you could please unmute.
Yes, ma'am.
Mrs. Stokes, as you have heard, the prosecution is willing to let Mr. Stokes return to the home and stay with you. Do you have any concerns about him living with you?
No, ma'am, I don't.
And do you have any concerns of him having a repeat offense of violence against you?
No, ma'am, I don't.
All right. Thank you. Please mute your screen. Miss Vigiletti, what is your recommendation?
Judge, I'm asking today for the court to consider dropping the jail time relating to Ms. Fox's recommendation. As I said, Mr. Stokes does have cancer. He is scheduled for surgery tomorrow afternoon. It's very important he keeps up with his treatment. He does receive treatment for medical and MH services in his home 5 days a week, 4 hours a day. So Mrs. Stokes is well supported and Mr. Stokes is well treated.
So you are in agreement with the other terms, but to reduce his jail time to serve 54 days, credit for time served 27 days?
Yes, Judge.
All right. The court has already had a separate virtual conference with the individuals, and which time there was a lot of discussion about his MH issues, his prior criminal history background, involving several incidences of violence. Mr. Stokes, it has been indicated that he's a former veteran, and that also based on the information provided about his current medical condition, this court is going to accept the defense's recommendation of 12 months to serve 54 days, credit for time served 27 days, with all the other requirements, including as required by the state, including the domestic violence program, no violence contact, no firearms, absolutely no firearms ever to be in possession of Mr. Stokes. Or he cannot own any firearms. He can't have them in his home. He can't have them on his person. He can't have it in a vehicle. So, Mrs. Stokes, if you ever wish to acquire a firearm, which is your right, either Mr. Stokes go or the guns go. As simple as that. Understood?
Yes, ma'am.
No, I'm directing that to your wife, Mr. Stokes. I'm not interested in whether you want to have a firearm. I'm more interested in Mrs. Stokes' desires.
Yes, ma'am, Your Honor, I understand.
All right. Ms. Vigiletti, do you stipulate to the factual basis, venue, and ID?
We do.
All right. Mr. Stokes, have you consumed any medication or alcohol recently?
Besides my, blood pressure, you.
All right.
and
Are you able to, okay, are you able to understand what's going on in your case so far, as well as what your attorney, as well as the discussions you've had with your attorney?
Yes, I do.
Are you satisfied with your legal services?
Yes, I am.
Is anyone forcing you or inducing you to take this plea offer today?
No.
And do you understand that this would be a conviction for battery family violence? In the future, if you ever get arrested for a same or similar offense, it will automatically be a felony charge, which means that you won't be treated as a misdemeanor case. It'll be treated as a felony case where you could end up in jail without a bond for a significant period of time. Are you still willing to move forward with the plea, knowing this information?
Yes, ma'am.
If you decide to plead guilty to this charge, you would have to give up your constitutional right to a trial before a judge or a jury. You will not have an opportunity to come back to court with your attorney, to confront your accuser, challenge the evidence brought against you, to present any defenses, arguments, and mitigating factors if you choose to do so, and have the state carry its burden to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
Are you entering a plea of guilty to battery family violence freely, willingly, and knowingly?
Yes.
And you understand there is no right to appeal from this sentence. This will be the final decision in this case.
Yes.
How do you plead to one count of battery family violence against Annette Stokes on December 22nd, 2021?
Guilty.
Your sentence is going to be 12 months to serve 54 days, credit for time served 27 days. The remainder of the time will be on probation. Miss Thomas, with regards to probation, I will allow him to do telephonic reporting for the first 3 months, which will be for the months of March, April, and May. After that, he will have to report in person for the rest of the 12 months. Do you understand, Mr. Stokes?
Yes.
I understand that Mrs. Stokes is willing to transport you to and from probation office. So for the months of March, April, and May, you can do it telephonically. But after that, you have to report in person from June 2024 onwards. And you must report in person at 132 Mitchell Street in downtown Atlanta. Do you understand, sir?
Yes, yes, ma'am.
While you're on probation, you will enroll in an online domestic violence intervention program at your expense. That enrollment must take place within 90 days from today. That means by end of May, you must show proof that you have enrolled in a domestic violence program. And that proof must be shown to your probation officer. Do you understand?
Yes.
And you must continue on that online classes. They are weekly classes, and you must continue with that consecutively without any breaks. Do you understand?
Yes.
You are to comply with all medical treatment, all MH treatment, whether it's counseling, treatment, and medication at all times. As already indicated, you're not to be in possession of any weapons and any firearms. If you get arrested again while you are on probation, probation is authorized to issue a warrant to revoke the rest of your probation and have you serve out the rest of this time in prison. Do you understand, sir?
Yes, ma'am.
That concludes this plea.
Thank you, Judge.
We have position number on the add-on calendar 1 through 4.
Okay. Mrs. Stokes, it will take up to 24 hours to release Mr. Stokes from the Fulton County Jail. So you might want to plan the pickup time accordingly.
Yes, ma'am.
All right, you're free to go. Thank you.
Thank you.
I'm sorry, could you repeat the position number? Is this a probation case?
No, 1 through 4 add-on calendar.
Add-on.
This is Jermaine Ivy. We did discuss his case without him being present.
All right. Mr. Ivy, I understand that the state and the defense have already agreed to lifting the bench warrants. So your cases shall be further noticed for trial. Make sure that you have a updated address and contact information with the courts at all times, and that you report to court when summoned. Otherwise, we get to arrest you again, and we do this all over again.
Yes, ma'am.
Thank you. That concludes this matter. Ms. Vigilante, are you ready to go into a breakout with ACDC?
Yes, Judge.
Okay,
All right. And are you using the computer in courtroom 2?
Yes.
All right. Ms. Grace, could you place courtroom 2 and ACDC into a breakout session?
Yes, ma'am.
Medical, is that, who do we have?
Next one.
Position number 5, Mr. Forts.
That's Mr. Mayor.
Ms. Vigilante, will you be filing a waiver of arraignment for Mr. Forts? Oops. Mr. Forts, we'll just need to hold until your attorney can confirm that she's filing a not guilty plea on your behalf. So medical, please keep it on mute until Ms. Vigilante returns. Thank you.
Your Honor, can you let me know which position this is again? Because I think I heard Forts.
FORTS, that's position 5 on the SAP calendar.
Right, that's the case that we announced we had the DA's office accepted transfer of the case, and we're
that's
waiting
right.
signature on the orders.
I beg your pardon. Thank you.
Not a problem.
If you like, well, Ms. Vigilante is not present, so. Mr. Clement Forts, your case is being transferred to the Superior Court to be tried as a felony matter. Would you like an opportunity to speak with your attorney before we proceed?
Yeah.
Okay, so please remain on hold until your attorney is available. Thank you. All right, I guess we'll be in recess until, let me see, what time is it? Mr. Bartel, are you available to do the CC calendar, the C calendar, competency calendar? Hello, Ms. McLeod.
Good morning, Your Honor. Good morning, Spoke.
All right. As soon as Mr. Bartel and Kasha appear, we can go into a breakout for our competency calendar, and Ms. Burgess as well. Thank you. Ms. Grace? Oh, no, Ms. Yeah.
Yes, ma'am.
We'll begin with the competency calendar. With the exception of medical, could you put the rest of us, including Mr. Bartel? Mr.
Yes,
Paul
ma'am.
Bartel, are you available?
Mr. Bartel is up here on 3 North.
Is he available to join us for the Zoom?
No, he's I think he's going to see some of his clients in person.
Could you let him know that we're ready to begin the competency calendar?
Okay, yes, Officer Blunt just went to go get him.
Thank you. All right, let's hold for Mr. Bartel, and then we can we go into the competency calendar to address Ms. McLeod's case, please? Ms. Grace, everybody who's on video right now, could you put us, with the exception of medical, do not put medical, but the rest of us, could you put us in a breakout?
Yes, ma'am.
And when Mr. Bartel appears, go ahead and put him in a breakout too.
Okay.
Ms. Vigilante, could you let Mr. Bartel know that we are starting our competency calendar and we need him in the breakout?
Oh, I have no idea where he is, but Mr. Haddad will go find him.
Oh, no, he's at medical. I was wondering if you could text him or email him.
Oh, sure.
Okay. All right, Miss Grace, go ahead. And while we're waiting, Miss Grace, you can place courtroom 2 and medical in a separate breakout room. Miss Grace is going to hate me. Mr. Fort would like to have a word with you.
I'm sorry, with me? I'm sorry, Judge. Mr. Fort is Mr. McLean's client and he's left for the day. I'm a little. Okay. Miss Grace, can I return to a breakout room with ACDC? I still have to finish my interview there.
Okay.
It's I have all 5, but. Here's the issue.
Just one moment, Mr. Haddad.
All right, courtroom 2, Miss Vigiletti. Is she still in the breakout? Mr. Haddad, who do you have? Is the individual at medical your client? Oh, that's Mr. Fort. We're waiting on Miss Vigiletti. All right. And Mr. Haddad, are you waiting on anyone in particular?
You have the open.
Judge, I have, in medical, I think Mr. Fort's,
Is this your
that's,
client or Miss Vigiletti's?
that's Mike McLean's client, I think, and Mike walked out of the courtroom. So I just need to speak to him and find out what I need to do on Fort's. And is Miss Falk on, I don't know if there's an offer on the case or not.
This is going to be transferred to the Superior Court to be tried as a felony matter.
Okay, then
So-
never mind. Okay.
So if you want to advise him accordingly, there's no offer on the table considering the transfer. We
Okay.
can put you in a breakout to speak to Mr. Ford unless you want to wait on Mr. McLean.
No, that'll be fine. I'll go break out and do that. The only other plea I have, he's in 5 North, Blake Kennedy. Just whenever he's brought, we're ready for a plea.
Understood. All right, thank you.
Judge.
Miss Grace, could you
Yes.
place Mr. Haddad in a breakout? Medical, you will see a message on the screen to join a breakout with Mr. Haddad.
I can't hear anything.
Hey, I'm sorry, Mr. Haddad, Mr. Blake Kennedy would not get up out the bed to up here before you, so he's also on 3 North, not 5 North.
Oh, 3 North, yeah. So Judge Law, I got lucky last night.
I don't know where that line goes, but okay, you better explain it.
Good point. I actually got Mr. Kennedy to come out of his room and we talked and I signed him up for a plea, but he has a history of refusing to come out. So hence my luck, but
Okay, well, I can always take a plea in absentia, sir, if you ever want to consider that. But
yeah,
is it time served, by the way?
it is time served, Judge. I'll talk to him and I'll draft the paperwork, the plea in absentia, Judge. That might be one way to do it, Judge.
All right. Or, it's always the case, if Mohammed won't come to the mountain, you may have to go to the mount yourself and take a visit this morning and see whether he wants to come out.
Right.
All right. It's entirely up to you, sir. Either way is fine with me. But please, we're going to put you in a breakout with Mr. Fords. And Miss Grace, could you let Miss Vigiletti know in her breakout that we are ready to address her cases?
Okay, Judge.
Thank you, Miss Grace. Mr. Paul Bartel, are you available? PD Paul Bartel. All right. We'll be in recess until Mr. Bartel and Miss Vigiletti appears. Yes, Mr. Haddad, Mr. Haddad, anything else to report? I'm sorry, you're on mute, sir.
Judge Law,
Yes, Ms.
Ms. Vigilante says she still has one more person to talk to. As soon as she's done, she'll be out.
Okay. Mr. Jawan Haddad, do you have anything to announce? You need to unmute. Wonder if he can hear me. Okay. All right, so we'll just be in recess until one of the PDs appears. All right, Ms. Vigilante, are we ready to proceed?
Yes, Judge.
All right, which case would you like to address first?
We could address on the add-on calendar, Alexandria Nieves.
Okay. When you hear your name called, please come forward to the computer. This is Alexandria Nicole Nieves on the state all-purpose add-on calendar. Positions 5, 6, 7, beginning with case number 22 CR 43208, simple battery family violence. Position 6 is 2 counts of criminal trespass under accusation 24 CR 9528 and a bench warrant under 24 FTA 177. Ms. Nieves, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and Ms. Vigiletti is your counsel. I apologize for that. As I was saying, your attorney is Ms. Vigiletti. Yes, Ms. Ms. Vigiletti, how would you like to proceed?
Yes, Judge, Ms. Nieves would like to enter a not guilty plea today. And I did, send a waiver of arraignment over yesterday evening.
All right. Ms. Nieves, your attorney has submitted a waiver of arraignment and entered a not guilty plea on your behalf. Your cases will be further noticed for trial, and you will receive notice of when your case will be scheduled for a jury trial before the division judge. Anything else, Ms. Vigiletti?
No, Judge.
All right, that concludes your case, Ms. Nieves. All right, next case, Ms. Vigiletti.
We could move to the probation calendar, position 1, Ms. Ty Kamen.
Yes.
This is State versus Ty Deja Kamen, accused of, convicted of theft of services under case number 22 CR 3925J. Ms. Kamen, this is going to be a probation revocation matter with regards to your particular case. You have a right to remain silent. Anything you say in open court, your statements can and will be used against you. Your counsel is Ms. Vigiletti. Officer Brooks, you have been already sworn. When was she convicted, and what's the basis of the revocation, and what's the recommendation?
Thank you, Your Honor. She was seen before Judge Batson on September 26, 2023 for theft of service. She was sentenced to 12 months probation. She's been in jail since February 26 of 2024. This defendant never reported to probation, not even one time. She has 220 days remaining on probation.
And the recommendation?
The recommendation is going to be to continue on probation since she has so many days remaining, and plus she also owes she owes a fine.
A fine or restitution?
Give me 1 second, Your Honor, and I'll get clarity. My apologies. Just 1 second, and I'll be able to tell you. It is restitution. She has restitution of $123.10, and then she has probation fees of $200 and victim crime fund fees of $40.
All right. Ms. Vigiletti?
Yes, Judge, I spoke with Ms. Kamen this morning. She informed me she had fallen on some quite difficult times after being sentenced to this probation. She's actually been in Peachford Hospital for 6 weeks, she tells me, and she has become homeless. And so after court today, I'm actually going to go see her, and we're going to work on getting some housing services together. I'm confident if she's put back on probation that she can get it done.
Okay. I'm going to record this as a probation violation. She will report to probation on Monday, which is going to be March 11th before 3 p.m. And she will report to probation every month in person. I'm going to waive her $200 probation fees, and I'll waive her probation fees for the next two months, including March. So March and April, she's not required to pay probation fees, but beginning May 1st, she needs to start paying her probation fees, where she needs to report every month.
Thank you, Judge.
She also needs to pay back her restitution, which is $123 in 10 months. She must make a payment of at least $20 a month for the remainder of the time that she has on probation. So beginning April, she needs to start paying $20 towards restitution and a minimum of $20 every month thereafter. Ms. Kamen, you are now required, to make those payments towards restitution. You failed to report to probation, failed to provide any notice that you were in the hospital, and failed to inform probation of where you were at all times. If you fail to report to probation and fail to comply this time, you have the pleasure of serving out the rest of your sentence in prison. Unless you would like to serve out the rest of your sentence in prison, that means you would have an additional 110 days left. What would you like to do?
The first one, I'd rather.
If you do the first one, you're supposed to report to probation every month, beginning Monday. And if you
Okay.
fail to do so, then you are left with no other options but to
Yeah, I'll
serve
be
out the
there.
rest of the time.
I'll be there.
All right. And as like I said, beginning May 1st, you need to start paying your probation fees, and you need to make a payment of $20 every month, beginning April of 2024.
And I pay that to my probation officer. The Officer Brooks is also, she's my probation officer, correct?
Officer Brooks may be your probation officer or maybe someone else.
So who do I pay? Do I pay the restaurant or do I pay
You pay
her?
it directly to your probation officer.
Okay.
Any other
That's-
questions?
No, that's it. And she said I will be released in 24 to 48 hours.
To report to probation on Monday, correct?
Thank you.
Thank you. Your next case, Ms. Bigiletti?
I'm sorry, excuse me, Your Honor.
Yes, Officer Brooks?
I just want to make sure I caught all of that. It was a little bit fast. I had trouble keeping up with my writing.
Oh, I'm sorry. Okay, she's going to be continued on probation. I'm going to waive her probation fees, the past due amount of $200. Waive her probation fees for March and April. She starts paying probation fees from May 1st, 2024 onwards. She reports on Monday before 3 p.m., March 11th. And beginning April 1st, 2024, she must make a minimum payment of $20 towards her restitution and a minimum payment of $20 every month thereafter.
Right here's been
This will be a probation violation on her record. And that was it.
Okay, thank you. I have it.
Okay, thank you.
Thank you.
All right. Next case, Ms. Vigiletti at ACDC.
Positions 17 through 21, Ms. Latoya Moore.
And what are we doing in that case?
I would like to discuss the possibility of a non-negotiated plea. I guess I'll just say up front, the only point that we'd like to negotiate, because this was an incident that happened with a parent and children. If the Family Violence Intervention Program, which is fairly targeted towards intimate partner violence, could be converted to anchor management.
Well, let's see what's going on. This is State versus Latoya Moore. She's got 3 cases on her calendar. The first one is 21 CR 6270E, accused of reckless conduct from March 1st, 2021. Position 18 is 22 CR 5751E, in which she's accused of battery, family violence, and cruelty in the 3rd degree from an April 29th, 2022 incident. And she has a bench warrant 24 FTA 207 from November 3rd, 2023. This is going to be a non-negotiated plea hearing. Ms. Moore, you have been advised of your right to remain silent, and your attorney is Ms. Vigiletti. May I place you under oath for purposes of the plea if one does move forward? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
All right. The state is going to indicate what is their plea offer, and your attorney is going to argue for an alternative recommendation. I will let you know which recommendation I will accept before you proceed with your plea hearing. Ms. Falk?
Yes, Your Honor. The state's recommendation on position 17 is 12 months probation, served 20 days, credit for time served 10 days. That's going to be from February 27th to March 7th of 2024. Balance probated, and we are requesting that she attend a parenting class. On position 18, the family violence battery, the state's recommendation is 12 months served 38 days, credit for time served 19 days. That's from April 30th to May 8th of 2022 and February 27th to March 7th of 2024. Balance probated, 40 hours of community service, family violence intervention program, no further violent contact with Ziona or Zariah Gant. That is Zionah and Zarriah. Last name Gant. Grant, Grant, and no firearms. Count 2 would be 12 months probation to run concurrent with count 1. We are recommending the family violence intervention program because the defendant not only has this case, but she's currently under a first offender sentence for aggravated assault and battery from June 21st of 2023. That is the date of her sentence. And we believe she would benefit from family violence intervention program based on the fact that her history, let me just double check before I make this statement, I believe is almost all violent cases. And so for that reason, the state still recommends and stands on the family violence intervention program as being a good program that we believe Ms. Moore could benefit from. That's all for the state. We would like to sound for the Mrs. Grants, Zariah and Ziona. And I apologize if I'm mispronouncing that name.
Right. No one's responding to those names. Ms. Vigiletti, is your client undergoing a FVIP from the felony matter?
If she did not disclose that to me, and I did explain what family violence intervention program is. So I believe she is not, but you tell me, Ms. Moore, did you already participate in the family violence intervention program?
Never.
Okay.
All right. So Ms. Vigiletti, what's your recommendation?
Yes, Judge, and this is based on, you know, when I started here a couple months ago, I did go to the Georgia.gov site that explains all of these different programs that we have. And my understanding of the family violence intervention program is that it is quite targeted to intimate partner violence. That's most of what they talk about. And that's not the situation here today. Ms. Moore, you know, when we talked earlier, she was telling me that she had some trouble with her kids in their young teen years. Did not always handle it well, but they're on great terms now. They're older. Zariah is 20 now and is actually her emergency contact for the probation case, if she takes probation. They're in a much better place, and I'm requesting anger management instead of the family violence intervention program today, because to me, if the family violence intervention program is heavily focused on intimate partner violence and anger management could address violence, could address other unhealthy ways that families are relating to each other. It just seems a more appropriate fit for this situation based on the fact that, you know, we're talking about family in terms of parent-child, not domestic partner violence.
Any response, Ms. Falk?
Your Honor, again, the state would stand on the fact that her history speaks for itself. Not only does she have that aggravated assault where she's currently on probation that it appears she did not take a family violence intervention program as part of. She also has this case, and it appears she was arrested in, and let me just make sure that's not our same case, because I'm showing an April 2022 arrest. It is not the same case for simple battery family violence. And so based on that, the state would maintain she would greatly benefit from this program. We're actually showing a September 1st, 2022 family violence battery arrest, an April 7th, 2022 simple battery family violence arrest, and then a March 15th, 2023 family violence battery arrest. So clearly there's something going on here.
Ms. Vigiletti, do you have a dispute with that criminal history record? Otherwise, I will ask Ms. Jackson to read her GCIC.
Yes, I don't have a dispute with the record, Judge. I just want to reiterate, I think anger management, we're not disputing that there could be a benefit of taking a class. I just think because the family violence intervention program is focused on intimate partner violence, and what we're talking about is not intimate partner violence, that anger management is a more appropriate way to address and support Ms. Moore in what she might need.
I have to respectfully disagree. Although the curriculum may skew towards intimate partner violence, the classes are also directed to individuals who fall under the umbrella of domestic violence partnerships, which can involve roommates who are not intimate and have previously lived together. It can include relations between parent and child, or also including, like you say, in other cases. I'm not certain if I'm about to enter into a debate as to the merits of the domestic violence program that is offered through the different schools. If Ms. Moore would like to avail herself of a domestic violence program that's skewed more towards alleged violence between parent and children, whether they be minors or adults, that's entirely up to her. But given her criminal history violence, given the fact that she has just been convicted of a felony matter, given the fact that she's got multiple arrests involving domestic violence situations, I am not persuaded that taking a few mere anger management classes is going to be any kind of rehabilitation for her. So I am going to require the a domestic violence program. She will have to begin those classes within 30 days of being released, and she must attend those classes every week at her expense. Her contact with any minor children and her will be in accordance with any defect supervision, if there is one in place. And also it will involve no violent contact, as well as with the two other individuals, Zara and Ziona Grant.
Zaria and Ziana.
Zaya and Ziana, yep. And I'm just reading the accusations. I'm concerned why they're not here to voice any support or any comment about this case.
Well, Judge, I just do want to remind you that we just got the offer during court today. So
Understood. We can always reset it if you want. That's not a problem for me, but she does qualify for a release.
Right.
And Your Honor, and let me just clarify, they just got the offer on the reckless conduct. They did not just get the offer on the family violence battery, which is the one that involves Mrs. Grant, and the one that she is debating the family violence intervention program on.
All right. So Ms. Vigiletti, that is the court's decision. Would your client still like to move forward with the plea or take this to trial?
Yes, Judge, we did discuss the possibility of this plea, and Ms. Moore would like to move forward.
Okay. Ms. Moore, I think I've already placed you under oath. Did I, Ms. Vigiletti?
Yes, you did, Judge.
All right. Do you stipulate to the factual basis, venue, and ID for position 17 and 18?
Yes,
Ms.
for the purposes of
Okay.
the plea.
Ms. Moore, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood what's been going on in both your cases?
Yes.
And you understand that the court is going to require you to undertake the domestic violence classes, and you must attend those classes every week until they are completed.
Yes, ma'am.
And you understand that failure to do so can result in your probation being revoked and you serve out the rest of the time in prison.
Yes, ma'am.
Are you satisfied with the legal services you've received?
Yes.
Is anyone forcing you or inducing you to take a plea today?
No.
If you decide to plead guilty to reckless conduct in one case, and to battery, family violence, and cruelty in the third degree in your second case, you would have to give up your constitutional rights to challenge these charges in a court of law before a judge or a jury. You will have to give up your right to have to be accompanied with your attorney, to be in a court of law, to confront your accuser, to challenge the evidence and witnesses brought before you, to present any defenses, arguments, and mitigating factors if you choose to do so, and waive your right to have the state carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
Are you entering your plea of guilt freely, knowingly, and voluntarily?
Yes.
How do you plead to one count of reckless conduct, which involved a minor child from March 1st, 2021?
Guilty.
How do you plead to one count of battery, family violence, and cruelty to children in third degree from April 29th, 2022?
Guilty.
With regards to the reckless conduct, your sentence is going to be 12 months to serve 20 days, credit for time served 10 days. You will report to probation on March 14th, which is next Thursday. And you must report to the probation office at 132 Mitchell Street in downtown Atlanta. And once you're on probation, you will complete a parenting class with regards to the reckless conduct conviction. And that class must be completed within 60 days of being released from jail. Do you understand?
Yes, ma'am.
With regards to the battery, family violence, and cruelty, the battery, family violence will carry a sentence of 12 months to serve 38 days, credit for time served 19 days, balance probated. You'll report to probation again next Thursday. While you're on probation, you will complete the family violence intervention program, which you must begin within 60 days of being released from jail. You will attend all classes consecutively with no breaks, and you must pay for those classes out of your own pocket. You will also complete 40 hours of voluntary community service at any nonprofit agency that's not a church and not a school. And you must complete those community service hours. You must begin those classes, those hours within 30 days of being released, and you must complete at least 5 hours a month.
Okay.
You are to have no further violent contact with the two misgrants that have been identified. You're not to possess any weapons, no firearms, no weapons, not to consume any alcohol, and no illegal drugs. You will be subject to random screens by probation. If you fail a screen, if you fail to report, if you fail to do your classes, your community service, or if you get arrested again for anything else, your probation can be revoked and requiring you to serve out the rest of the time in prison. Thank you.
Okay.
Position number 19, the bench warrant is null crossed. Next case, Ms. Vigiletti?
Yes, positions 23, 24, and 25, Miss Deja Smith-Johnson.
How are you proceeding there?
I will say this for the record, just because I did tell Miss Smith-Johnson I was going to request a conversion from Family Violence Intervention Program to anger management. I don't know that we need to have that debate over again, since this is very similar to the previous case that involves violence with relatives.
Okay.
And so in light of that, Ms. Smith-Johnson, unless you tell me otherwise, I think we're prepared to proceed with a plea today. No? Okay.
All right, Ms. Smith-Johnson, as you have 3 cases also. Position 23 is a bench warrant, 24 FTA 209. That was 23. Position 24 is 18 CR 040A, accused of criminal trespass, simple assault, family violence, and battery family violence from December 26, 2017. And position 25 is 1 count of criminal trespass from July 2nd, 2019. Ms. Smith, you've been advised of your right to remain silent. Your attorney is Ms. Vigiletti. May I place you under oath for purposes of the plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you.
Your Honor, the state does have an inquiry. Is Miss Smith-Johnson also pleading to the added case 24000938? The disorderly conduct and obstruction.
That involves the stay away from the quick trip?
Yes.
Yes, we discussed that.
Okay, that was case number 24 CR 000938A, 1 count of disorderly conduct.
Yes, Your Honor, and 1 count of obstruction of an officer.
Okay. All right, so that is 3 separate cases that we are addressing. So I'm assuming this is going to be a global offer. What is it, Ms. Falk?
Yes, Your Honor. The state's offer we have agreed to null pros position 23 upon the entry of this plea, position 24 on count 1, 12 months probation concurrent with count 3, excuse me. Count 2 will merge with that count 3. Count 3, we are agreeing to reduce that down to a simple battery family violence. I will submit the amended accusation on that. The recommendation is 12 months to serve 104 days, credit for time served 52 days. That's going to be from December 26th to December 27th of 2017, July 21st to August 17th of 2018, December 11th to December 22nd of 2021, and February 27th to March 7th of 2024. We are also asking for no further violent contact with Teresa Gullat, Gullat, Family Violence Intervention Program, and 40 hours of community service. On position 25, the criminal trespass charge will be 12 months probation concurrent with 18 CR 00040A, no further violent contact with Lee Johnson, and the added case 24 CR 000938 on count 1, the disorderly conduct, 12 months probation to run consecutive with 19 CR 0010256A. Balance will be suspended. Stay away from the Quick Trip located at 4745 State Route 138, Union City. On count 2, the obstruction of law enforcement officer will be 12 months concurrent with count 1. So it's going to be a total of 24 months, the first 12 months to be served on probation. There will be family violence intervention program, 40 hours of community service, no further violent contact with Teresa Gullat and Lee Johnson. Stay away from the Quick Trip located at 4745 State Route 138 in Union City. And she will have served 104 days, credit for time served 52 days. That's all for the state. We would like to sound for Ms. Gullat and Mr. Johnson, and we would ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea on all 3 cases.
We do for the purposes of the plea.
Just to clarify, count 1, disorderly conduct, it will be 12 months consecutive to position 25. Is that correct?
That is correct, Your Honor. We're doing 24 months probation with 12 months on active probation, and then she can go to a suspended sentence after that.
So she needs, okay, so is balance suspended upon completion of the first 12 months of probation?
That is correct.
Okay. All right, Ms. Vigiletti, are those the terms to which your client has agreed?
They are, Judge.
Okay, Ms. Smith-Johnson, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood your cases and the recommendations by the prosecutor?
Yes, ma'am.
All right, and are you satisfied with your attorney?
Yes, ma'am.
If you decide to proceed with this plea on all 3 cases, you would have to give up your constitutional right to challenge these charges in a court of law before a judge or a jury. You will not have the opportunity of having an attorney to go back to court. Did you have a question?
No, ma'am.
You will not have the opportunity of confronting your accusers, to challenge the evidence brought before you, to be able to present any defenses and arguments, and have the state carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
Are you certain? It looks like you're not sure.
I'm certain.
Okay. On position number 24. I beg your pardon?
I'm positive.
Okay. On position 24, 1 count of criminal trespass and 1 count of simple battery family violence. How do you plead?
Guilty.
Your sentence is 12 months to serve 104 days. Credit for time served, 52 days. The remainder of the time will be on probation. You will report to probation on March 14th before 3 p.m. at 132 Mitchell Street in downtown Atlanta. While you're on probation, you will complete a family violence intervention program. This is a 24-week program where you have to attend classes every week. You will begin those classes within 60 days of being released from today. Let me think. Yeah, you have enough time. Yeah. So you must begin those classes within 60 days of being released. You're also to complete 40 hours of voluntary community service at any nonprofit agency, which is not a church and not a school. And you will begin those community service work within 30 days of being released with a minimum of 5 hours per month. Do you understand? You will report to probation every month, and you are to have no contact with Teresa Gulat. With regards to position 25, case number 19 CR 0102568, criminal trespass, how do you plead?
Guilty.
Your sentence is going to be 12 months probation concurrent with position number 24. You are to have no violent contact with Lee Johnson. Do you understand?
Yeah.
With regards to the third case, 24 CR 938A, disorderly conduct and willful obstruction of an officer, how do you plead?
Guilty.
I'm not convinced that you are entering this willingly and knowingly. If you want to give me that attitude, I mean, I can just schedule this for trial. Miss Smith-Johnson, if you want to show any degree of remorse or any degree that you're genuine about your plea, I'll be willing to accept it. But I don't have a problem rescheduling this case for trial.
I'm just ready to get it over. I'm guilty.
No, I don't care whether you're willing to get it over with. You've got 3 criminal cases against you. And I don't like that kind of attitude from individuals.
I apologize. I'm guilty.
I'll accept your guilty plea for the disorderly conduct and the willful obstruction of an officer. On the disorderly conduct is going to be 12 months probation, and that's going to be consecutive to position 25. The state has offered to suspend your probation. I am going to require it to be non-reporting. It is not going to be suspended. If you finish your first 12 months of probation satisfactorily, then the remainder of the 12 months on position on the disorderly conduct will be non-reporting, which means that you're still technically on probation. But if you get arrested again for anything else, we will have an opportunity to revoke your probation and send you out to prison to serve out the rest of the time. Do you understand, Miss Johnson?
Yes, ma'am.
Thank you. On the willful obstruction of an officer, it will be 12 months probation concurrent to the disorderly conduct charge. So with the exception of everything else, her probation will be non-reporting for the disorderly conduct. Thank you. All right, Ms. Vigiletti, are we concluded with ACDC?
Yes, Judge.
All right. Deputy Milton, was there anything else to address?
I believe we completed everything, Your Honor.
All right, thank you.
Thank you for everything.
No
Bye,
problem.
everybody.
Take care, everyone. Mr. Paul Bartel, is he available? Because I was just waiting on him to. No, not yet. Okay.
Sorry, Judge, here he is.
All right.
Yes, good morning, Your Honor, or good afternoon. Sorry I wasn't available earlier.
No, that's quite all right, as long as you do appear, so I was
Right.
concerned. Okay. Mr. Bartel, let's go ahead and do a competency calendar.
Well,
Ms.
yeah.
Grace, do we return to the same breakout, or do you have us in a different room?
A different room, Judge.
All right, so with the exception of ACDC, could you put everyone else on video in the breakout room, as well as Ms. Champion?
Yes, ma'am.
It's a legal transfer.
Hi, my name is Samira Jones, and I'm being bullied by the Union City Police Department. I never committed a crime in my life. Okay, bye.
You have to turn the phone like 5 minutes. Yeah, they'll come.
Not here, the police that live in my, that work in my state jurisdiction. It's not here.
Yeah, I feel you, that's real. They step in. I mean, it's so fun, you don't use it, they don't use it. They set you up, especially if you.
Okay, I'd like to go over the probation revocation calendar briefly. Maybe we can get an update. Is courtroom 2, any deputies in courtroom 2 at the present time? Ms. Vigilante? Oh, Mr. Haddad. Okay, good. On the probation revocation calendar, position 1, Cameron was continued on probation. Position 2, Carter continued on probation. And position 8, Zatar Hunt, what did we do?
I was at an interview at that time, Judge. He had open cases on SAP and probation. He was Mr. McLean's client.
I think, Judge, that's the one that ended up being reset for next week.
Okay.
So Mike Mr. McLean can look into something. I remember him saying that.
No, you're correct. You're correct. I just didn't write it down. Ms. Brooks, Officer Brooks, position 8 and 9 are reset to probation revocation on March 14th. Okay, then moving back to position 3, Antonio Carter, I think that one was addressed already. He's continued on probation. Position 4, Freddie Coney or Freddie Conley, position 4 and 5.
Judge, I think that the warrant was pulled, that he should have been released. That's according to probation. I got an email. We all got an email from them yesterday that.
Okay. I just want to confirm that. Officer Brooks, is that correct?
Yes, Your Honor, that is correct.
All right. So 4 and 5 is released.
I'm sorry.
Go ahead.
My apologies. I didn't catch what you said for the reset date for Hunt.
Oh, March 14th.
Okay.
Today. Position 6, Bridget Gary and 7.
Yes, Judge, that's the same as Freddie Conley. He was released, or she was released.
Just folks, I read your emails, but I didn't note it on the calendar. That's why I'm just going over it just to make
No
sure.
problem.
And that concludes the probation revocation calendar. Thank you, Officer Brooks.
Thank you.
All right. The add-on calendar. Jermaine Ivy, positions 1, 2, 3, and 4 has been released, correct?
He will be.
Will be, all right. Pursuant to the consent order.
Yes.
All right. Position 5, 6, 7, waivers of arraignment and entry of not guilty plea.
Yes, Judge.
Position 8 is a duplicate. Position 9, Daryl Stokes. What did we do?
That is also a duplicate. Daryl Stokes is the gentleman with cancer.
That's
That
right.
is correct, Your Honor.
All right, thought the name sounded familiar, so let me just go ahead and do that. Okay. Add-on calendar. Position 1, Anthony Burgess was a plea. Position 2, Crosby is a waiver of arraignment and further notice for trial. 3 was null prost. 4 was a plea. 5, Forts is transferred to Superior Court as a felony matter. 6, Leroy Grayer is a plea. 7 and 8 were pleas. 9, Howard is arraigned and further notice for trial. Same announcement for position 10. Position 11, 12, reset to March 14th at 9 a.m. Is that correct? Along with this probation matter?
Yes, ma'am.
Position 13 is reset to March 14th, 9 a.m. Along with 4 other cases. Ms. Champion, did we have those 4 other cases?
Yes, ma'am, I have them.
All right, appreciate it. Thank you. Position 14, Blake Kennedy. I think Mr. Haddad was asking something about that again.
Judge, if we can just maybe reset it for next week, just in case I can't do a plea in absentia, whatever. I mean, at least I need to get confirmation from him whether he wants a jury trial or not if we don't resolve it as a plea. So if we can have just a catch-all next week, just to make sure that it doesn't fall through the cracks, because I can't Again, in all honesty, right now, waive arraignment plead him not guilty because he had indicated to me that he wanted to plead guilty. So
Understood? March 14, because unfortunately Tuesday is full.
that's fine, Judge.
Okay, so March 14th at 9 a.m. for a possible plea or a plea in absentia.
Thank you, Judge.
Position 15 is Matthias Kopp, K-O-P-P. Mr. McLean or Ms. Vigiletti?
Juane,
Yes.
position 15, Matthias Kopp.
Oh,
Matthias?
Judge, I'm sorry. Waive arraignment, plead not guilty. And I'll submit the waiver of arraignment today, Judge.
I'm so sorry, I lost Zoom for a minute. Can you all hear me? Can you hear me?
We can hear you now, Judge. We're gonna
All
waive,
right, great.
we're gonna
Yes,
waive arraignment and plead him not guilty. I'll file the appropriate paperwork today, Judge.
All right. Matthias Kopp is further notice for trial. 16, Montes Ayala was a plea. 17 and 18 and 19. Sorry, 17 and 18 were pleas. 19 is null crossed. 20 was a plea as well. Oh, that's null cross. 20 is a null cross. That was the bench warrant. Okay, so 19 and 20 of null cross. 21 Horus Newson was a plea. 22 Redden was a plea. 23 that's Miss Deja Smith Johnson. 23 is null crossed. 24, 25 are pleas, as well as the additional case of 24 CR 938A, which is a plea. 26 Stinson is a plea. 27 Stokes is a plea. 28 Stokes is a null cross. That's the bench warrant. 29 Reginald Walls is transferred to Superior Court. 30 Wilborne is a plea, and 31 is arraigned and further notice for trial.
Your Honor, can I get an announcement again on, I think I have everything covered except for positions 7 and 8, Preston Harris.
Oh, Preston Harris was a plea.
Okay.
So position 7 was a plea and position 8 was a plea.
Thank you, Your Honor.
Yeah, I missed that page completely. Okay. Yeah. All right. Any questions, Ms. Vigiletti? Did we cover everything consistent with all the emails that we received and all that?
Yes, I think we're all set here. Thank you.
All right. No, I appreciate you sending all that information. I just get lazy about saying, okay, I'll make a note of it down the road, but I'm sorry. But I do appreciate the information. Thank you.
Thanks, Judge.
All right, Mr. Haddad, and we'll see y'all soon. And
See you next week. Thank you.
yeah, thank you, Mr. Bartel, and everyone.
Judge, are you handling the Orca calendars next week? I was just curious. I'll be there.
You know, I had plans to enjoy my weekend and not think about it, but now that you have to make me doing that, no, it'll be Judge Morrow, and he will be doing the Orca calendars for next week.
All right. All right. Thank you, Judge.
All right, y'all take care then. Thank you.
Have a good
Ms.
week.
Champion, I'll be here waiting for those documents. Thank you.
Okay.